It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my speechifying co-host, Brett.
Oh, Alice, you and your puns. They're never ending. Never get tired of them.
Well, see, here's the thing. Speechifying, I know, is not exactly like the greatest connotation, and I don't mean it in a negative way, but the core word in it directly relates to something we're talking about today, First Amendment free speech, and I just wanted people to make the jump logically, quickly, instead of having to be like, loquacious.
I know.
What does that have to do with speech?
You just have so little faith in our audience, I guess, is what you're saying.
It's not faith. I just really like the ties across the board. Words are fun. Words are great.
Words are great. Words good. And the legal briefs, like this is boom, 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 go, go, go. So there's no time for thinking about how it's
we only have 30 minutes 30 minutes is like when we go get coffee, Brett, you and I, we're like, we want to go get a quick coffee. And like 2.5 hours later, we're like, oh, it's been 2.5 hours. So 30 minutes is literally like a drop in the bucket.
And the fact that we try
how long we talk
and describe some of these cases and legal principles in 30 minutes is really insane. You could...
I think we should get an award for it.
We probably should. In most law schools, there's an entire class on the First Amendment. An entire semester-long class. At least one.
I was going to say, it was a year long. I mean, we took it our first semester of law school at Yale, and really that was because it was the baseline to then take all of we call them law and classes. So the First Amendment in media, First Amendment in print, et cetera, because there's so much to talk about. And it's so interesting because all of us care about free speech. We all have voices, whether spoken, written, at home in the public square. So it affects all of us. And I think that's partly why people are so interested in it.
It does. And today we're going to talk about NetChoice versus Paxton, which is a case out of Texas, which is about free speech online. So what you can say on social media, what social media companies can do to restrict your speech, what governments can do to prevent social media companies from doing that kind of thing. And this is a subject that people wanted us to talk about, so I blame you guys that we're going to do this. We're going to try and do this in 30 minutes. So we're really giving you some high-level stuff here. This is a case, if you don't know about it, almost certainly is going to go to the Supreme Court for reasons we're going to talk about. So you're going to be hearing about this, and hopefully, if you hear this episode, you'll at least have some familiarity with it. So when you hear discussions about it, you're not confused about what is going on. So as Alice said, we don't have a whole lot of time, so let's just dive into this, and let's start with First Amendment principles. And I think the most basic way to describe the First Amendment is more speech good, less speech bad. And that was the sort of animating principle behind the founders and the First Amendment. The thought was that, yes, there are bad things that people say, and they are detrimental, and people tell falsehoods, and people mislead others. But if you have more speech, eventually the truth will out. And the founders really believed that, and they thought that's the way you should do things, and that's why the First Amendment is in the Constitution. I think this is important because some people have a very cabined view of the First Amendment. The First Amendment only applies to government. It only restricts government's ability to restrict your speech. And so sometimes you'll see people who, if it's not the government acting, they act as though there's no problem with censorship and in other areas. And the one thing I would say about that is the First Amendment comes from a principle. And the principle is more speech good, less speech bad. And that's why you have the First Amendment. We talked in our other podcast recently about the Salem witch trials. And as we're talking about that, there are all these orders coming down from governments restricting people's ability to write about that, to talk about it. And that was a bad thing. And that was what animated the founders to have the First Amendment. But just because the First Amendment itself only applies to government doesn't mean that the greater principle of free speech being a good thing isn't something that we should defend and that we should care about. And that's really where this whole case comes in. So we're talking about Twitter, we're talking about Facebook, we're talking about social media. Obviously, those companies can and often do ban people, and they do it for various reasons. And some people claim that the reason they're banned is because of a particular political view or philosophical view or religious view. And obviously, if Twitter bans you because of your speech, you can't sue them for restricting your speech, at least under the First Amendment. You can't say, I have a First Amendment right to free speech, therefore I'm suing Twitter. Because, as we just said, the First Amendment applies to government, not to private actors. And Twitter is a private company. It's not a governmental entity. And only governmental entities are covered by the First Amendment itself. But Texas decided to do something and pass a law that raises a more interesting question than that. So can a state or the federal government pass a law requiring a social media company to allow speech essentially without restriction? Can they, with a law, go beyond the protection of the First Amendment? And if they do, does that actually violate the free speech rights for the companies themselves to decide what speech will appear on their platforms?
So, in an opinion from the Fifth Circuit, the court said yes to the first question and no to the second. Real quick, just to remind y'all, there are the federal courts of appeals. The Fifth Circuit is made up of Texas, Louisiana, and Mississippi. And remember what we talked about with precedent and what's binding? The Fifth Circuit binds courts within the Fifth Circuit. So, for example, California is in the Ninth Circuit, not in the Fifth Circuit. So courts in California are not bound by the Fifth Circuit, though it could be persuasive. So really, that was a really quick kind of broad overview of the federal courts of appeals. Now, the statute prohibited social media platforms from prohibiting speech on the basis of viewpoint. Essentially, it did to the social media public square what the First Amendment does to traditional public spaces. Just as the government cannot prohibit you from speaking in the park because of your viewpoint, Twitter can't prevent you from speaking in the digital proverbial public park because of your viewpoint. So we use Twitter because it was the main opponent of the bill. Twitter's position was that it and it alone could decide what speech to allow on its platform, and it could do so for any reason. If Twitter decided it was an enemy of, say, the LGBTQ community, then in Twitter's view, it could ban any positive commentary about that community. In fact, Twitter agreed to do just this scenario at oral argument, recognizing that it's kind of an inflammatory point of view. But their point is, we are a private company, we are not a public park, and therefore we get to run our business the way we see fit, which includes discriminating based on viewpoint if we see fit for our business plan.
An oral argument is like that. You always have the judges that are coming up with the worst case scenario for your position. So you have Twitter who's saying, look, we can ban anybody for any reason whatsoever. And so you have a judge who says, so if Twitter decided that it didn't like gay people, it could ban any positive commentary about that community. And Twitter has to say that is correct, because unless they can come up with some exception to that, if they say, no, that would be going too far, then the court has them. Then they're just going to rip them apart. Well, where's the limit? Why can you do it here, but you can't do it there? Why would that be a problem given your theory? So Twitter has to take this very sort of extreme view, which is our company, our platform, we can ban anything we want for any reason we want. And so the Texas legislature disagreed. And they viewed Twitter as something akin to a common carrier. In enacting HB 20, the Texas legislators found that the platforms, quote, function as common carriers, are affected with a public interest, are central public forums for public debate, and have enjoyed governmental support in the United States. So the legislature further found that social media platforms with the largest numbers of users are common carriers by virtue of their market dominance. And so when they pass this legislation, it only applies to companies with so many users. I don't remember what the exact number is, but it's a lot. So it's going to capture Twitter, it's going to capture Facebook, it's going to capture the big people. If you have sort of a small business social media platform, which I don't know if those exist, it would not necessarily be captured by this. But the biggest companies would be, and that's pretty common. There's a lot of legislation that will often have those kind of limits, so it really only applies to the biggest of the biggest, and that's what they did here. And this whole common carrier thing is fairly significant because traditionally common carriers aren't free to do just whatever they want. So common carriers are things like trains, buses, telephone companies, just companies that generally are involved in sort of the commerce across the country. And the idea has always been whatever you might do in other private businesses, we're not going to let you do that with common carriers. For instance, even at common law, a common carrier could not refuse service on the basis of race, for instance. So they could segregate it before Brown versus Board of Education, and that's where many of the battles of the Civil Rights era came from. So you couldn't have a bus line that did not allow African Americans on the bus because you're a common carrier. You can't discriminate against them in that way. So what they did is they would segregate the buses and they would segregate the trains. And it was that same sort of idea. And that's where a lot of the Civil Rights era battles were fought, was over, is segregation itself a violation of those deeply held principles? And so the idea is common carriers, they enjoy a natural and sometimes a government-supported monopoly over service, and thus they lack the freedom to just decide not to serve someone. If you're the city bus company, you have a governmental monopoly. If you are AT&T, you have a natural monopoly because when you own all the telephone lines, you have a monopoly and no one else can decide, well, we're going to put up telephone lines too. We're just going to have like 13 different telephone posts running down the road, each with a different person's telephone line. That's not how it's going to work. So you have a natural monopoly. So there's going to be limits on what you can do, whereas traditionally, if you're just a business owner doing your own thing, you can do whatever you want. So based on this status, Texas is saying, Twitter, you are a common carrier. We have more power over you than we would sort of a normal, ordinary company. And so we are going to limit what you can do when it comes to things like speech. And we're going to say you cannot censor users of your platform.
So the companies responded that this was a violation of their First Amendment rights. And it is true. Corporations do have rights. You've probably heard this in the news, whether it's positive or negative. Corporations are people too, for purposes of the law like this. For instance, in Citizens United, the Supreme Court held that a corporation's right to participate in the political process is protected by the First Amendment. And you probably heard, if you were around during the coverage of Citizens United when it came out several years ago, it was corporations are people, corporations are people. The idea there was that a person may spend money advertising in the political process. If 2 people or 10 people or 100 people who do not have the resources of one wealthy individual join together to make their voice heard, why shouldn't their speech be protected? Obviously, Citizens United is controversial, but it is the law of the land because it is a Supreme Court opinion. So, based on Citizens United, shouldn't the companies win in this case out of Texas?
And that's a great question, right? So you've got this Supreme Court precedent. It says that corporations have free speech rights, and they're saying our free speech rights are being violated because we are being forced to speak, right? I mean, that's essentially what they're saying. You are, by not allowing us to keep certain people off our platforms, you are forcing us to deliver their message. And this is a pretty common First Amendment attack. So you have different attacks on the First Amendment. It can be things like limiting your speech. So saying you can't, ahead of time, we're not going to allow you to speak, which is deeply disfavored. So, for instance, in Citizens United, the whole issue was there was a law that basically said corporations, I forget the amount of time, but I think it's 30 days before an election, 30 days before an election could not spend money in any way on politics. Citizens United wanted to put out books and videos and everything else, and would not have been able to do that within 30 days of the election. And the Supreme Court said, no, that's sort of prior restraint on speech. You can't do that. It's a core fundamental right. Citizens United gets to do it, even though they're a corporation, so they win. And the other thing that you'll often see is people who don't want to be forced to carry a message. You see that sometimes in license plates. It's sort of is an area where you see this. So states like to put things on license plates, and there have been lawsuits where people say, look, I don't want it to say God bless America on my license plate. That's not a position that I support. So you shouldn't be able to force me to do that. And you have these battles over forcing people to engage in speech. And that's essentially what Twitter's saying. So the Fifth Circuit disagreed with them, and they distinguished between expressive content, which is what we've been talking about. So what the company itself says, what Citizens United wanted to say, what you're being forced to say on your license plate, and censorship, what the company doesn't let someone else say. So they said, look, there's two kinds of content here. There's expressive content, there's what you want to say, and there's you stopping other people from speaking. What you want to say, you can say whatever. I mean, Twitter can tweet whatever it wants to tweet from its company platform, and nobody can stop them. And if somebody tried to, that would be a violation of their First Amendment rights. But here, you are not speaking, you are stopping someone from speaking. And importantly, it's black letter law that what you say on a company's platform is not the speech of the platform. And that is a position the platforms will argue to the death for a very important reason. Section 230 of the Communications Decency Act protects tech companies like Twitter, like Facebook, like YouTube from being sued precisely on this idea. So, say that you decide to tweet something defamatory, or you put a video up on YouTube that steals all of Taylor Swift's music, right? Well, subject to certain exceptions, in that if I say, hey, take down this video with all my copyright, they have to do it. The law says they are not liable for that. So Twitter is not liable if you post something defamatory on Twitter. They are protected from that. They can't be sued from that. You can be, but they can't. And this is incredibly important to them. And they will tell you that without 230, they would go out of business. They would just be sued into oblivion if they didn't have this protection. And the Fifth Circuit kind of says, look, you can't have it both ways. Either what is posted on your site is expressive, in which case it is protected by the First Amendment, but not by Section 230, not by that thing that gives you immunity, or it is not expressive, in which case you have 230 immunity, but not First Amendment protection.
So you can see how this is like a rock and a hard place for these big platforms like Twitter, because they want it both ways, right? That's what the Fifth Circuit said. We get that you want Section 230 protection as well as the First Amendment, but those are in tension with each other. So you have to choose one or the other. You can't not be held liable for what people are saying on your platform, but also block what people are saying. Now, the Fifth Circuit summed it up. They said, we first reject the platform's facial overbreadth challenge because Section 7 does not chill speech. If anything, it chills censorship. Then we, B, turn to the First Amendment's text and history, which offer no support for the platform's claimed right to censor. Next, applying Supreme Court precedent, we see hold that Section 7 does not regulate the platform speech at all. It protects other people's speech and regulates the platform's conduct. Our decision is reinforced by 47 U.S.C. Section 230, which reflects Congress's judgment that the platforms are not, quote, speaking when they host other people's speech. Our decision is still further reinforced by the Common Carrier Doctrine, which vests the Texas legislature with the power to prevent the platforms from discriminating against Texas users. Finally, even if all of that's wrong and Section 7 does regulate the platform speech, it satisfies the intermediate scrutiny that applies to content-neutral rules.
We could spend a whole 4 or 5 episodes on what intermediate scrutiny
There's a lot there.
There is a lot there, but I think a lot of it reflects what we've already told you. So the first thing is, look, this isn't chilling your speech because Twitter can say whatever it wants. Twitter can say whatever it wants. If somebody tweets something that Twitter finds deeply offensive or wrong, you actually see this on Twitter, right? I mean, during the whole COVID-19 pandemic, they had set it up where if you tweeted something that said like the vaccines don't work, automatically Twitter would play something on your tweet that would say this tweet contains misinformation. In reality, the vaccines are perfect and are wonderful, right? And they can do that. And the court's like, look, nobody's limiting what you can say. Nobody's limiting your speech in any way. All that's being limited is your ability to tell someone else they can't speak on your platform. And so that's sort of the first thing where they sort of make a little distinction there. And that's important because the First Amendment has routinely been found to protect expressive conduct and not non-expressive conduct. And there's a bunch of examples of this. There are cases, malls. So you have a mall is a private place. It's private property. But in the 80s and 90s, not so much now, but in the 80s and 90s, the mall sort of replaced the public commons as the place that people go. So before, if you wanted to talk to people, maybe you go to the park and people would come to the park and you'd talk to them, right? But as malls grew up, if you really wanted to reach people, you needed to go to the mall. And so malls tried to stop you from doing that. They wanted to forbid people from passing out leaflets, forbid people from engaging in certain speech. And in case after case after case, courts said no. Malls are private property and they have certain rights, but they have become the commons. They are now the sort of area where people go to speak. And since that is true, we're not going to allow you to stop them from speaking. And one of the reasons is no one thinks that some guy with a sign that says, everybody's going to hell. No one thinks that's the mall, right? Nobody's like, man, the mall's really some religious bigots over here, right? Like nobody thinks that. They don't assign to the mall the speech. So the mall is now the public place. It's where everybody goes. It's now the public commons. Nobody's assigning the speech to the mall. And so the court said, sorry, malls, you have to let these people in within reasonable, restrictions or whatever. My property class in law school was all about this. Like the whole class was about access to property. It was kind of weird. And I think our professor didn't really believe in property. He's kind of a communist. And so that was the whole thing was about. And so we read all these cases about this very kind of thing. And now the court is sort of relying on that to distinguish between what Twitter is saying and sort of the reality of the situation out in the world, which doesn't mean this wasn't an incredibly controversial decision. There are a lot of people who strongly believe, number one, that Twitter should be able to ban people, and number two, should ban people, that they have sort of a moral obligation. So imagine, people who are advocating for Nazism, right? I mean, just imagine the most extreme people. People, the Ku Klux Klan's Twitter handle, or the neo-Nazis' Twitter handle, just the most extreme thing, or like the International Communist Anarchist or whatever, right? There's a lot of people who think Twitter should be able to stop those people from speaking because they're dangerous and they are spreading horrible ideas and they are polluting this whole platform and they're leading people astray and all sorts of other stuff. And if Twitter doesn't want to have those people on its platform that it built, It shouldn't have to. And that's one sort of position. Another position, which you might call sort of a libertarian position, is this is a private company. This company built this platform, grew this platform, and for the government to tell it now, you have to do X, Y, and Z, and you have to allow this on your platform, is an affront to sort of basic capitalist ideas. And we shouldn't allow that. So you have sort of two groups of people who don't necessarily always agree with each other, sort of right libertarians, and then maybe sort of more social liberals who are agreeing on this, that this forcing Twitter to allow people onto the platform is not a good thing. And those people came out pretty strongly against this and had some pretty powerful criticisms. We're going to put a lot of these articles on the website. We'll put the opinion on the website as well as some of these articles you can read, so you can read the criticisms of this decision. But the first criticism, which is probably the main criticism, is what about editorial discretion? So editorial discretion has been something that the Supreme Court has repeatedly said is a core First Amendment right. Newspapers are one of the best examples of this. Newspapers traditionally have the right to decide what to publish. So if you write a letter to the editor or an op-ed and the newspaper doesn't like it and they don't like what you're saying, they have no obligation to publish it. They can just say no. And they can say no because they don't like your viewpoint. So they can ban you from the newspaper based on viewpoint, which this law prevents Twitter from being able to do the same thing. And this is just widespread, right? I mean, newspapers generally do and must decide what to publish. Now, the counter to this and what the court said was newspapers are very different from Twitter. So Twitter doesn't actually decide what to publish in the aggregate, writ large. The tweeters do. Twitter might block some people here and there, but generally speaking, people publish whatever they want to on Twitter, unlike a newspaper where every single thing that goes in the newspaper, the editors have to agree on. And going back to this expression and going back to malls, people read it in the newspaper, they are going to assume that says something about the editorial board. And you see this all the time. You'll see pure opinion op-eds written by someone who doesn't work for the newspaper in the Wall Street Journal or the New York Times or Fox News or CNN, and people will assume that is the position of the New York Times or CNN. And you'll see people criticize New York Times or something in an op-ed. And there is some truth to that in that they have to decide to publish that. But Twitter, unlike newspapers, second thing, they have unlimited space. So newspapers have limited space. They have to make these kind of decisions. It has to be a part of being a newspaper is to make these kind of decisions. And just as importantly, when the newspaper decides to publish something, a specific op-ed or a letter to the editor, it necessarily excludes others and, has some expressive content on the part of the newspaper in that the newspaper agreed of all the things we could publish, we are going to publish this. And it is hard to say that anything tweeted by anyone represents the views of Twitter unless it's by sort of the company handle itself.
So another criticism is that common carriers, as the Fifth Circuit has applied it to Twitter here, doesn't make sense because common carrier doesn't apply to radio stations. So why should it apply to social media like Twitter? Once again, kind of like the newspaper example, the radio spectrum is not unlimited, nor is what you can play on the radio. There's time and space restrictions, right? Each radio signal only goes so far, and there's only 24 hours in a day. It is not just a free-for-all that you can play on every station at every time. You have a particular wavelength for your station. So if you play one thing, you necessarily cannot play another. It would essentially be impossible for radio to be treated in the same way as the internet because the internet is the opposite, like we've talked about. It is absolutely unlimited in bandwidth.
And what's really interesting about this case, just in general, is I think you can see there's not necessarily a right answer here. In a lot of the cases we talk about, we think there's pretty clearly a right answer, either based on precedent or based on the law or based on the Constitution. You go back to the Miranda case that we talked about several episodes ago, and it was that could you sue for a violation of your Miranda rights? Could you sue on the basis of a violation of your constitutional rights because you weren't read your Miranda rights? And because the Miranda warnings are not constitutional, but are rather a prophylactic rule to protect your constitutional rights, we thought the answer that the Supreme Court came to, the majority came to, pretty obvious. No, you can't do that because it's not a constitutional right. This is much more amorphous. This is, do you buy this philosophically? So, does this make sense to you? Maybe it doesn't matter. Maybe it should not matter that the radio spectrum is limited and that newspapers are limited. Maybe that fact is not enough to make Twitter different enough from those that you should be able to do this to them. Or you might hear that and think, that's a pretty good point. That's a good point and really makes a big difference. And look, why should it make a difference? Because a lot of this, kind of going back to the Citizen United thing, yes, the Constitution applies to corporations. The Supreme Court has said that several times, but it doesn't apply to corporations in the same way it does people. Advertising is a good example of this. There are limits that the government can put on advertising. How far those go can be a little shaky. Good example, cigarettes. You don't see cigarettes advertised in the United States. Now, that is at this point because of a voluntary agreement by the cigarette companies not to advertise. But for a long time, it was basically just understood that it was illegal for them to advertise. And there was always this question, like, is this actually constitutional? Can you limit this? And there were Supreme Court cases that basically said, yes, advertising is speech, but it's not speech in the same way, and it's corporate speech, so it's a little different. It's not like you standing on a soapbox in the park speaking. You know, there is a distinction between your rights and a corporation's rights, and how far do those corporate rights go? And so that's why these things matter. And I think it's really interesting just to see some people think this decision is just so wrong. They think it is completely and utterly wrong. And they just can't even believe that any court would come to this conclusion. And some of the articles we'll link to, that's their position. And it's just really interesting to see that. And I'm interested, frankly, to hear what you guys think. But it's not just people writing in the newspaper about this that disagree. So we talked about the Fifth Circuit. The Fifth Circuit covers Texas, it covers Mississippi, it covers Louisiana. Well, then there's the 11th Circuit, which covers Alabama, Georgia, and Florida. And interesting trivia for the law nerds out there, used to be one circuit. There used to just be the Fifth Circuit, and it covered all 6 of those states. And then at some point they decided...
1989?
Earlier than that. It was like 1981 or 1982.
1981. It's 1981. You're right.
At that point, they decided
same case we always cite.
That's Bonner versus City of Pritchard. At that point, they split these 2 circuits in half. So everything before then, all Fifth Circuit law before then, actually is binding in the 11th Circuit. But all Fifth Circuit law after that, just a different circuit, it's not binding. Well, that's important because the 11th Circuit had basically the same law out of Florida. And they considered that statute around the time the Fifth Circuit was considering the Texas law and came to the exact opposite conclusion. They struck down the Florida law. They actually enjoined it. And when they did so, they essentially held that the social media companies do have a First Amendment right to editorial control. So the thing that we've been talking about, they have editorial control over what is published on their platforms, and therefore, by limiting that, that is an unconstitutional law. And here's what they wrote about that. More particularly, when a platform removes or deprioritizes a user or post, it makes a judgment about whether and to what extent it will publish information to its users. A judgment rooted in the platform's own views about the sorts of content and viewpoints that are valuable and appropriate for dissemination on its site. When a platform selectively removes what it perceives to be incendiary political rhetoric, pornographic content, or public health misinformation, it conveys a message and therefore engages in speech within the meaning of the First Amendment. So that's a pretty interesting take. I mean, basically they're saying, no, it is true, the unlimited space thing is what it is, but at the end of the day, the fact that Twitter is saying, no Nazis on our site, that itself is expressive content by Twitter, because it is conveying a message to everyone that uses it that we disagree fundamentally with that viewpoint and we are not going to allow it here. And that itself is expressive. So that's the position of the 11th Circuit, which is counter, obviously, to the position of the 5th Circuit.
So you can see how, like we were saying, there's no clear answer here. And we've tried to tell you exactly what the reasoning is on either side. And, two courts who, were considering really the exact same legal question came to diametrically opposed reasons. And this is fine. This is what the circuits are for. And when there's enough of a circuit split and it's a question that the Supreme Court feels they need to weigh in on, they will. And so this is exactly what we expect in circuits. It is not unusual to see a circuit split. This one is pretty stark, and it obviously, Twitter doesn't just operate in the 5th Circuit or just operate in the 11th Circuit. So there does need to be some clarification because I think these big platforms don't quite know what they can or cannot do in these different circuits. And as we know how the internet works, I mean, you don't just get one feed of Twitter in Texas that's different than Florida. The internet is, across the United States, pretty much the same in terms of what you're getting. And so that's why this has created a lot of questions and a lot of people asked us to cover this. And we hope we've at least given you the baseline because, like Brett said, we could talk about this for an entire podcast, really, not just one episode of Legal Briefs.
Yeah, and one thing that I think is really interesting about this, so I am very familiar with the judges who wrote the opinions for both the 5th Circuit and the 11th Circuit. And there's a lot of people out there who will tell you that judges are basically politicians in robes and they just, whichever party appoints them, that's the way they're going to go. And look, there certainly are certain subjects where it is probably true that if you're appointed by a Republican or a certain president versus another president or a Democrat in general, you're probably going to tend to go one way or the other. But a lot of things that happen in the courts are actually really complicated, like this. This is really complicated. And both these judges, if you look into their history, they're both appointed by the same president, both have very similar sort of what you would think of as judicial philosophies. And in tackling this very difficult question with these big sort of constitutional and free speech implications, came to the exact opposite view. So it is sort of an interesting thing and sort of puts a lie to some of this notion that judges and judicial opinions are really they're just political and why do we even care about them? This is a really good example of two people grappling with a lot of history, a lot of precedent, a lot of big ideas, but in the end, both of them looking at it through the lens of sort of trying to get it right, they come to the exact opposite views. And as Alice said, I think this probably will be taken up by the Supreme Court, and it will be really interesting to see which way they go, because I think there's probably a lot of ideological divide amongst the various justices of the Supreme Court on how exactly they're going to look at this, and I think it'll be fascinating to watch how this area of the law develops in the future.
Indeed. I think that's exactly right. Well, I can't believe we actually were able to fit this into one episode, but you give us a challenge and we rise to the challenge. So we hope you guys enjoy this episode. As always, write to us, especially if it's a case like this where you just like to know a little bit more. And there's a lot to know about in this case. This could easily be a follow-up if you all wanted it. But before we sign off for the day, Brett, do you have anything else to add?
Yeah, just echoing what you just said, this was very, very surface level discussion. We gave you the quick and dirty First Amendment and the quick and dirty on two really long opinions. We're going to post them online. You can read them. You can read some of the criticism. And, I think this stuff is fascinating. I think a lot of you guys who listen will find this fascinating as well. So we were happy to bring this and keep giving us these interesting topics to cover.
Well, this has been an awesome ride, as always, with you all. Thank you guys for tuning in to Legal Briefs. We have so much fun doing it. It is such a fun show to do, and we're only able to do it because of all of you. And thanks for always supporting us on our other podcasts as well, the Prosecutors Podcast. And until next time, I'm your host, Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. quick. The Fifth Circuit is Texas and Louisiana. Is that it?
In Mississippi.
I was like, I'm missing one. This is really bad. This can be in the bloopers. I will allow it. I clerked on the Fifth Circuit, and the fact that I could
That's
not
pretty
name
bad,
the third
actually.
state, I think this just shows you how tough it is to work all day since 7 a.m., not have slept last night, and after putting the kids to bed and cleaning up the kitchen, making a Lego monster truck because my child wanted it.
Wow, wow, wow.
To then talk about the Fifth Circuit. Wow, wow, wow. All to say. Okay.